Hello, good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to come with some great news. So, we got a very important decision from the Supreme Court today. And the Supreme Court has determined that the Biden administration can terminate, as they wanted to before, the Remain in Mexico policy, where and this policy was based on Title 42. So this is a type of statute. So under the immigration law, this was a statute that enabled the government to enforce the law whenever there was a threat to public health, that they could then turn around and expel an immigrant who they think posed a threat in a country that had a communicable disease. And in this case, the justification was that was COVID-19. So they were saying that this is a public health threat, and immigrants, the influx of immigrants coming in from Mexico and on the Mexican border would create a public health crisis for the United States. This was implemented during the Trump administration. And so when the Trump administration did this, it created a lot of additional problems for immigrants who needed to come into the United States for assistance. So can you imagine being a refugee, being an individual who is seeking asylum, and you are trying to get into the United States, which that's what the United States is known as. It is known as a country that takes in refugees. And imagine being told at the border that you are going to have to stay in Mexico, where they have nowhere to go, where they have not sought refuge in Mexico, and there are dangers there because they're in such a vulnerable state. First of all, they had many individuals camping right on the border, homeless and camping on the border. And so that created squalid conditions for them. They were exposed to, COVID-19 and other types of threats at the border, and violence as well. Because remember that there are individuals there are individuals who are seeking to take advantage of their vulnerability as they are trying to get into the United States. And so the Remain in Mexico policy was inhumane, and it created problems for those who were stuck in Mexico or who were expelled. And so the Supreme Court today has decided that based on the statute, so what they did was they interpreted the language in the statute to see if the Biden administration was required to continue to enforce this policy. And because so remember, Texas, Missouri, among other states, sued the Biden administration the minute the Biden administration said that they were ready to terminate this inhumane policy, terminate the use of Title 42. And so the states, led by Texas, sued the Biden administration to try to force them to continue, saying that Title 42 required that they continue to expel immigrants to Mexico or detain them, but they could not take them in and then release them into the United States. The Supreme Court, so the opinion was led by Justice Roberts, and Justice Roberts looked at the language in the statute and determined that nothing in the language of the statute requires that the Biden administration carry out either detention or expulsion. It said that the Biden administration may, and may usually means that they are not required. It is an option for them, but it is not a requirement. And in addition to that, the Roberts also pointed out that finding otherwise would endanger the ability of the Biden administration to carry out their duties in regards to diplomacy. Because remember that this policy also required required the Biden administration to work with Mexico. And so it would be affecting his ability, it would be interfering with his ability to conduct diplomatic matters. And so here we have it. We have an opinion that thankfully is in the favor of immigrants. And while the opinion was based on statutory interpretation, meaning that it's not necessarily, because of ideological reasons that the justices are, for example, Roberts is a known conservative, and this was not based on them simply looking and saying, oh, how is it going to affect immigrants, but rather they looked at the technical language of the statute and they came to the right decision. So for that, I'm very happy with this decision, because remember, we just experienced a tragedy in San Antonio, Texas, where 53 individuals who were being smuggled in a tractor trailer truck died from heat. And died from heat. Can you imagine going through that suffering? And the smugglers that took them across abandoned them on the side of the road as if they were nothing. Children were among these individuals. And then in addition to the deaths, you have some that are in the hospital in varying conditions. But the reason that these kinds of things happen is because of policies like the Remain in Mexico. If you have policies like that and you have people who are desperately trying to seek refuge, they are going to do things like this to try to bypass legal immigration. And so I think the solution here is not to come up with cruel policies like this, but rather to figure out how to fix the immigration system to make it easier for those who deserve to be here to get through the process legally. And so this is a good start in that it does allow the Biden administration and the Department of Homeland Security and the Immigration Service to carry out their enforcement of immigration policies. And so they are deferring to the Biden administration and their duties, their powers to carry out and enforce immigration law. So it's good news, and I'm happy to bring this news today. I know I've had in the past to come with disappointing news about immigration reform, and so it's good to know that at least the Biden administration can this is one step that they can take to try to fix the regulations, or they're trying to fix the situation so that it's a more fair and humane immigration system. So that's what I have for you today. I think that is good news, and I'm going to leave it there with what I have. Now, the next thing that I want to do is answer your immigration related questions, and I see a ton of them. It's so good to see you all. And once again, I am on here from usually around 4 p.m. to 4:30. I have been busy getting clients their green cards and getting really good results for my clients. And so I took pause to make sure that that my clients were taken care of. But now I am working on getting my schedule back on track. And this means that I will be here every day, Mondays through Fridays at around 4 p.m. to give you good immigration information. So now let me go ahead and answer your immigration questions. So I have a question. What happens if you have a voluntary deportation? What can I do? So now when you say voluntary deportation, I'm trying to figure out if that means voluntary departure. So your case is going to be a little more complex, just because if you've been granted voluntary departure, we would have to figure out what your options are after the order. Is there any new evidence in your case that could change that? Now, if you're talking about voluntary deportation, as in you self-deported or you left the country voluntarily, we would also have to look at what your circumstances are, what are the facts involved in your case to determine the best way to approach it. So that's where the consultation is going to be very important. Can you travel out of the United States and a green card when you are convicted with two DUIs? It may be possible. So can you travel out of the United States? That's going to depend. I would really have to understand what your situation is. Repeated DUIs can be a major problem, especially when it comes to US citizenship. But we'd have to understand, how long ago did these DUIs happen? What were the circumstances surrounding the DUIs? Did you get do you call it a DUI, but was there a reduced charge? So schedule that consultation. Let's talk. Before you travel, you're doing the right thing by asking that question here, because before you travel, before you even apply for US citizenship, you do need to understand the implications of those DUIs. So go ahead, schedule a consultation. You can get in touch with us by simply going to the link in the profile. You can go to the website. You can schedule your own appointment if you want to. And thanks for the follows. Thanks for the love, by the way. Do they have refugee camps in America? So you wouldn't call them refugee camps. I don't know what you're getting at. You have to be more specific. Please, I have a question. I'm from Africa. When I was making my national identification, and it finishes there, so I don't know. So can I become a Mexican citizen if my daddy was born in Mexico? I'm not a Mexican immigration attorney, so you'd have to consult an attorney in Mexico. After you submit joint sponsorship for spouse in Guyana, how long you have to wait for your interview? So interviews are taking anywhere from 3 months to even over a year right now. Hi there, Jay Hines. So nice to see you. Can you please tell me what is the marriage-based green card interview timeline in Atlanta? I've been waiting, so from 14 months. So I wouldn't be able to tell you a timeline. Remember that all the information I'm giving you here is estimated. And so when we're talking about adjustment of status, it really comes down to what's going on in your case. What's the situation? I know that my cases are taking around 6 to 8 months, but that does not mean that it's guaranteed for you. And then, we don't know what the situation is with your process. So, Jahan, that's where it's very important for you to get personalized legal advice, to get a better information about what your situation is. So what was the news? So the news, Olivia, was that the Biden administration tried to end Title 42, which is the Remain in Mexico policy. People who were trying to seek asylum in the United States were told that they would have to wait in Mexico. They were sent back in Mexico, many of them, and told that they have to wait in Mexico to be able to wait for their hearings or wait for a decision on their asylum. And, can you imagine what kinds of dangers and conditions that presented to those individuals? Well, that happened during the Trump administration in 2019. The Biden administration decided to end that policy. And when they announced that they were ending it, Texas led a group of states to sue in trying to force the Biden administration to continue the policy and either expel immigrants or continue to detain them. And so this went all the way through to the Supreme Court, which is the highest court in the land. And they decided that the Biden administration did have the power to end Title 42, and they couldn't be forced to continue to enforce it. So that's good news. So I want to stay here. Yes, I signed a doc. I've been trying to be legal for years. So Evelyn, the cool mom, schedule a consultation. We'll have to talk about what happened. Were you represented by an attorney? What did you sign? It's your case is complex and it's very, very specific. But I can help as long as I can understand what your situation is. So go ahead, schedule a consultation, and then we can talk in detail. My priority, 5/14/18 SIJS, when a visa will be ready for me. I have a work permit, SSN, but no physical. And I don't see the rest. So yeah, so the good news is that those who have SIJS status can get a work permit and their social security, but you do have to wait for your priority date to become current, and that's gonna really depend on the type of relationship that you're applying based on and where they are in the process right now. All right, so great questions. Keep these questions coming. All right. How long does it take for you to get a green card in the mail after you get approval notice? So it could take a week, it could take a few weeks. How long does it take for the I-130 petition to be reviewed? So, I've seen I-130 petitions sit there for a year, so 9 months to a year to get a decision. Can you change from a J1 visa to a green card? It's possible, but you still have to qualify through family, through an employer, through you do have to qualify. And so there are so many different ways. There are over 20 ways to get a green card, and you have to fall into one of those. And whether you can stay here is going to depend on whether under that category you qualify to stay here. Let's see. How long does the USCIS take to accept your sponsorship? So it takes, when they arrive, it's going to take, so when they arrive, when it arrives at the USCIS, they usually will post when they've accepted it. What is the time frame for the I-130? 9 months to 12 months, and it depends on the category that you're applying for. I am IRCR Guyana, already DQ. When will I receive an interview letter? So it depends. Three months to it could be 3 months, could be up to 12 months. Can you be called for interviews when applying for the I-130? It's possible. I've seen it happen. Okay, so all right. Why the asylum case is dismissing now, so I don't know. Now with the asylum, so let me tell you, I don't know what's happening with your particular asylum case. That's where it's very important for you to get a consultation. But what I can tell you is that they are dismissing cases that they think because of the burden and the backlog right now, they are dismissing some cases. And so they're choosing which ones to dismiss based on maybe how long you've been here and so forth. Now, it's very important for you to understand your options, whether you want to move forward. Are they giving you the option? Do you want to go through the process? That's where you should go ahead and schedule a consultation, and then we can talk about what your options are, and do that as soon as possible. All right, so that's going to be it for me today. Thanks so much for your time and all your relevant questions. I appreciate it. I'm going to be back tomorrow at around 4 p.m. Eastern time. So I'll see you tomorrow. I'll come with a great topic, and you can come with your questions, and then we can go ahead and talk about the topic and your questions. All right. Thanks everyone for your time. I'll see you tomorrow. Bye bye. See you tomorrow, Seema.